Okay, I left off within the Reference Guide to Regulatory Compliance, subpart 2 about credit, RESPA, page 259, servicing requirements, covered under Title 12 of the Code of Federal Regulations, Chapter 1024.2, which discusses the coverage of the servicing requirements, being servicers that include any person responsible for servicing a federally related mortgage loan, including receiving any scheduled payment, such as those for escrow, making the payments to the owner of the loan or other third parties, and in the case of reverse mortgages, making the payments to the borrower. Exemptions from the servicing requirements, according to the FDIC or the NCUA, in connection with assets acquired, assigned, sold, or transferred. And according to Fannie Mae, Freddie Mac, HUD, Ginnie Mae, FHA, FSA, or VA, when the assignment, sale, or transfer of the servicing is preceded by the termination of the contract for servicing for cause, commencement of proceedings for bankruptcy of the servicer, commencement of proceedings by the FDIC or NCUA for receivership or conservatorship. The definition of servicing is receiving any scheduled periodic payment from a borrower on a federally related mortgage loan and paying the owner or another third party. Wow, I really would have given the servicing definition first, then maybe the exemptions, and then maybe I would give the definition of servicing, the examples of servicing, and the exemptions. Regardless, the disclosure requirements, form language, and ability to be provided electronically and use of abbreviations is explained here. For servicing transfers, a servicing disclosure statement within 3 days after an applicant applies for a first lien mortgage loan, lender, mortgage broker, or dealer must provide to the applicant a servicing disclosure statement that states that the mortgage may be assigned, sold, or transferred to any other party at any time, effective soon, October 3rd of 2015. This requirement will apply only to reverse mortgage loans. And that's because the servicing disclosure statement is going to be part of the consolidated TILA RESPA TRID disclosure. A servicing disclosure statement does not have to be provided to an applicant if the application is denied within 3 business days. Coverage, this notice is required by transferor servicers and transferee servicers for transfer, sales, or assignments of mortgage loans. Exclusions, the following are not considered assignments, sales, or transfers when there is no change in the payee, address to which payment is delivered, account number, or payment due. Those would be including transfers between affiliates, transfers that result from a merger or acquisition of servicers, or from a transfer between master servicers where the sub-servicers remain the same. And the FHA is not required to send a notice when mortgages are assigned to the FHA. So what they're saying is that the actual servicing disclosure statement isn't required under those circumstances because they're not considered assignments, sales, etc. Transfers, because there's no change in the payee. Well, timing of the servicing disclosure statement, both the transferor servicer and transferee servicer must deliver to the borrower a notice of transfer. The transferor notice must be delivered not less than 15 days before the effective date of the servicing transfer, and the transferee notice must be delivered not more than 15 days after the effective date of the servicing transfer. Notices may be combined and delivered to the borrower not less than 15 days before the effective date of the servicing transfer. In the following cases, the notice of transfer must be delivered to the borrower not more than 30 days after the effective date of the transfer of servicing. The servicing contract is terminated for cause, the commencement of proceedings in bankruptcy of the servicer, or when the FDIC or NCUA commences proceedings for conservatorship or receivership of the servicer. Those are the only cases when more than 30 days can pass before the borrower receives the servicing transfer notice. I was just a little lost because at first I thought we were just talking about a servicing disclosure statement, but apparently at some point we switched over to discussing a servicing transfer and the disclosures associated with that. I didn't realize they referred to as servicing disclosure statements. I thought I was upfront within 3 days of the application, but perhaps I'm missing a page here. Content of notice of transfer must contain the effective date of the transfer of servicing, the name, address, and a toll-free or collect call telephone number of the transferee servicer, the name, address, and a toll-free or collect call telephone number of an employee or department of the transfer servicer who can answer questions about the servicing transfer, the date on which the transfer servicer will cease to accept payments, and the date on which the transferee servicer will begin to accept payments. Information concerning any effect the transfer may have on the terms or the continued availability of mortgage, life, or disability insurance, or any other type of insurance, and the action of the borrower must take to maintain the coverage, and a statement that the transfer of servicing does not affect any other term or condition of the mortgage documents. Late fees during the transfer of servicing are not allowed for the first 60 days after a servicing transfer if the borrower made payment on time to the old servicer. And the treatment of payments under this section, beginning as of the transfer date, payments that are incorrectly received by the transferor servicer must either be transmitted to the transferee servicer or returned to the sender with a notice of the correct recipient of the payment. Servicers will be deemed to have complied with any state law requirement for notices of servicing transfer if they comply with this section. Escrow payment requirements, completely different section under RESPA. I would think this isn't relating to the transfer of servicing, but I could be wrong. But as I read it now, timely disbursements within that section. If a borrower is required to make payments into an escrow account for taxes, insurance, etc., the lender must make payments for these items in a timely manner and to refund escrow balances within 20 days. This is a separate issue, but if there's an escrow surplus, it must be referred within 20 days of the payment in full of a mortgage loan. The servicer must refund the balance of the escrow account that is within the servicer's control. If a borrower agrees, the servicer may credit the balance of the escrow account to an escrow account for a new mortgage loan, provided that the loan is with the same lender, is assigned to the same lender, or is serviced by the same lender. Oh, I'm sorry, this is not the escrow surplus. This is at the end of, if you make a final payment of towards principal on your loan and there's a balance in the escrow account, this is how it should be handled within 20 days of paying off the mortgage. There's error resolution procedures under RESPA, and the section applies to any written notice received from the borrower that asserts an error or includes the name of the borrower. And includes pieces of information to identify the error being described, which is the name of the borrower, the information enabling the servicer to identify the mortgage loan account and the error that the borrower believes has occurred. A written notice on a payment coupon or other payment form supplied by the servicer need not be treated as a notice of error. A qualified written request that asserts an error is technically what's being accepted and referred to as a notice of error, and the servicer must comply with the QWR requirements. Error includes the following and any other error related to the servicing of a mortgage loan. And you have some examples of errors. By some, I mean 8, 9. These include failure to accept a payment that conforms to the servicer's requirements for making payments, failure to apply an accepted payment according to terms of the mortgage and applicable law, failure to credit a payment in a timely manner, failure to pay taxes, insurance premiums, or other charges that the servicer is supposed to collect and pay, or to refund the escrow account as required, imposing a fee without a reasonable basis for the fee, failure to provide an accurate payoff balance upon the borrower's request, failure to provide accurate loss mitigation options or foreclosure information, failure to transfer accurate and timely information to a transferee servicer, making a foreclosure filing or posting a notice that violates Reg X, moving for foreclosure in violation of Reg X, and any other error related to the servicing of the loan. A servicer is not required to comply with these requirements but must notify the borrower of that fact within 5 business days if any of the following apply. That is, a notice of error is duplicative and the servicer has previously complied with these requirements, or the notice is overbroad and a specific error cannot be determined, or if the notice is untimely, which means it's delivered 1 year after the servicing was transferred from the servicer to a new servicer, or the mortgage loan was discharged. Address of the where the QWR is sent, a qualified written request, that is. A servicer must respond to a notice of error as follows unless a servicer may designate an address for the receipt of notices or errors, and for receiving written requests, it must be the same address. Just to further note that there. A servicer must provide written notice of the address to borrowers and post it on the servicer's website. When responding to a notice of error, a servicer must respond as follows unless the servicer corrects the error within 5 days, or unless the notice is not timely, is duplicative, or overly broad. Otherwise, the servicer must correct the error and provide the borrower with a written notice of the correction, the effective date, and contact information for further assistance, or the servicer conducts a reasonable investigation and provides the borrower with a written statement that no error has occurred and the reasons for this determination. A statement of the borrower's right to receive documentation replied upon and by the servicer in making the determination, and information regarding how the borrower may request such documentation. But we are missing a piece here about how in the response to the qualified written request, it has to be acknowledged within, I guess, 5 days, unless it can be responded to within 5 days. Nevertheless, different or additional errors. If the servicer determines that a different error or additional errors occurred, the servicer must correct the errors and provide the borrower with a description of the errors and action taken to correct the errors, the date of the correction and contact information for the servicer. Requesting information from the borrower. In connection with investigating an error, a servicer may request information from a borrower but may not require the borrower to provide the information as a condition of investigation because the borrower did not provide the requested information. Time limits. A servicer must investigate and respond to a notice of error within 7 business days, there you go, after the servicer receives notice of a payoff error. Okay, so I completely misinterpreted this when I was reading about, timely payoff requests. So we're talking about payoff requests now, excuse me. Prior to the date of a foreclosure sale or within 30 business days after the servicer receives a notice of error, whichever is earlier for errors related to foreclosures. Not later than 30 business days after the receipt of the notice of error for all other errors, this time limit may be extended. So apparently what I'm getting from this is that the only requirement of the servicer to acknowledge the error is if it were relating to a payoff. It's got to be acknowledged within 7 days. And there's also a requirement to respond within 30 business days for errors related to foreclosures, and you can extend this requirement by another 15 business days if the servicer notifies a borrower of the extension and the reasons for it in writing. No extensions are allowed for